Welcome to the Binary Agora. With us today, we have Chris Meyers, who's been the Associate General Counsel on EU competition law at Amazon for the past 6 years. So welcome to the Agora, Chris.
Thanks, Alba. Thanks for having me.
So some of our audience members might not really know about this Amazon case, but this case has transformed and it really comes from a long lost succession of interactions with the German Competition Authority surrounding how it sets prices on its store, especially relating to parity requirements. So the long saga of MFN clauses. How do you, Chris, explain this U-turn from the German Competition Authority where it has shifted from the application of the abuse provisions to the application of the new Section 19A?
Yeah, thanks, Alba. It's a good place to start. And maybe I'll give a little bit of background on where we're coming at leading up to that question. We are obviously challenging this FCO decision. It is primarily based on this new regulation regime, Article 19A, as you say. And as we see it, it just directly conflicts with the consumer welfare standard as it's been applied consistently across these types of cases. As a result of this decision, Amazon would be the only retailer across Europe and in Germany that would be forced to promote uncompetitive and high prices to our customers, which just doesn't make sense for our customers. It doesn't make sense for selling partners. It doesn't make sense for competition. And it's important to understand that the Amazon business model, of course, our store is built to ensure that customers can confidently find the best value based on price, delivery speed. That's why they keep returning to the store. And if we're singularly mandated to promote uncompetitive or abusive prices in our store, it just is going to lead to bad shopping experiences, misleading customers into thinking they're getting great value when in reality, they're really not. That customer first approach that we've always taken for decades with our store ends up supporting the success of about 50,000 selling partners in Germany. So selling partners are extremely important to us. We have fair policies that apply equally to all the sellers and all the offers in our store. Those sellers account for about 60% of our sales across the stores. Those sellers help contribute to offering the vast selection, the competitive pricing, convenient delivery that everyone enjoys across the Amazon store. And they do freely and independently set their own prices. But just like any other retailer, we don't want to have to promote uncompetitive prices to our customers. It just negatively impacts their trust in the experience. And that will impact selling partners longer term too, because they will then be selling in a store that's not as attractive to customers that customers will not really trust to begin with. On the pivot point then, with that sort of background specifically, the investigation did begin many years ago, maybe 4 or 5 years ago, as an MFN inquiry. And then the DMA came into force really effectively in March of 2024. And after that, the case shifted to different theories, even though the scope of the case didn't change or expand. At the beginning of the new regime, the FCO was pretty clear, right? They stated that they would use the Article 19A tool to designate, specific technology companies. They've now designated all 5 of those companies that they identified, including us, and they're imposing obligations on each of them using the kind of open-ended Article 19A. In a case like this, where we really believe the pro-competitive benefits that result from our practices are so clear for customers, but also really important for sellers longer term in benefiting from the trust in their store, it's hard for us to accept the case and move on. The core of what the Federal Cartel Office is focused on, primarily how the featured offer, where we do promote an offer that customers can trust and buy with confidence, knowing that they're not going to regret that purchase later. That's really what the case is focused on, and that's unfortunately where the pivot has led to.
Actually, on that point, on the conflicting nature of this Section 19A with the consumer welfare standard, I would say DMA and Section 19A style regulations aren't really about consumer welfare, but they have other objectives in mind. Building on that idea, Amazon has also significantly faced backlash with regards to its price parity clauses. So not only via this sanctioning proceeding, but also by Article 5.3 of the DMA, which basically prohibits parity clauses from appearing in the markets that the European Commission designates. And it also takes an issue with the bundling of data when displaying its prominent offers in its interface. So how do you understand this overlap between Section 19A, the DMA, and how do you see the FCO or the European Commission's obligations to reconcile how those instruments play out in practice?
We are strong believers in the EU single market. It really is the strength of the EU fundamentally. It's the foundation of competition law across Europe. I learned that decades ago. And it really is core to how we run the business. We do run the business in a way that's really focused on an integrated market and a single market across all of Europe. On the MFN issues themselves, as you said, I joined about 6 years ago here at Amazon. The Amazon MFN issues preceded me. So we had, from what I understand, some residual contractual terms in our marketplace agreements that we didn't really enforce, but we're still there. And so as we got some scrutiny around that, we quickly figured out how to resolve that. And we got rid of those terms, not just in Germany, not just in Europe, but more globally. We just eliminated those. I think maybe some of that fed into the DMA, but from what I saw, I think the DMA provision itself on Article 5.3, the MFN parity provision, was probably driven more by practices of other companies that are now covered by the DMA, I would guess. But obviously now that provision does apply to everybody who's covered, and it does apply to us. We are confident that what we're doing with respect to these practices comports with the DMA. I've been under the DMA now for just coming up on 2 years. We are confident our practices are consistent with that, but they are regulated by it, right? Like it is the exact same conduct and the exact same practices that the FCO is looking at. Broadly speaking, I often recall Commissioner Vestagier's words as the DMA was being promulgated, and she said, we want a single European rule book. We've tabled the DMA in order to avoid fragmentation. Whatever you think of the DMA as a whole, that is an important goal and quite critical to how a regime like this can run. It was adopted as a harmonizing regulation, and we still see this type of member state investigation and cases being brought where you do have pretty clear conflict in the way that the DMA overrides it. I think, as the FCO leadership said last week publicly, they believe they've identified a quote-unquote thin line that lets them proceed with the case, even though it does cover the exact same practices and touches on the provisions of the DMA, like this MFN provision, but potentially also others. We don't really understand why, when you do have this harmonizing regulation of the DMA, you would look for thin lines on which to base enforcement cases, to prioritize your cases, especially when those cases are positive for customers. As you said, there may be different goals. The DMA has a fairness and contestability goal, of course, but fundamentally, if you're pushing and adopting a decision that's going to be negative for customers and not necessarily positive for the sellers in our case either, where longer term the sellers are going to not benefit from an Amazon store that is less attractive to customers, including their customers, longer term. It's a challenging situation to be in. There's a lot of opportunity for thinking more broadly about how we rationalize these regimes in a way that you do get to something that is efficient and coherent and avoids the kind of outcome that we're facing today.
Building on this harmonization objective of the DMA, and then Section 19A was passed within that interim where the DMA was being negotiated, I was wondering, as a result of this case, will we in the end have a different German marketplace as opposed to the EU experience that Amazon users have in the rest of the EU, right?
That is really what we're challenged by. We've had cases 102 side under abuse of dominance where we resolved with the European Commission, but the exact same conduct still was allowed to proceed in another member state like Italy, for example. And in those cases, you do end up with different outcomes. You end up with a solution that you release and launch across the rest of the EU member states, and then something different in one country. That for sure is a negative outcome, not just for us and customers and sellers, but really for the single market, right? And how you best promote in this period where there's general recognition the single market is the place to kind of center and build European economic strength and future development. It's heading in the opposite direction of that.
The German Competition Authority, within the press release, it was quite bold because it did not only set out what it had presented as a theory of harm to Amazon, but rather it also introduced some comments by the chief of the Bundeskartellamt, and within that prohibition of imposing on Amazon on those price control mechanisms, the Bundeskartellamt's president added a few remarks by saying, for instance, that, quote, influencing Amazon's competitors' pricing, including through price caps, is only permissible in the most exceptional cases. I was going to ask you whether this is reasonable to try to introduce as a theory of harm by the FCO, especially as we were saying, because consumer welfare in the end will be reduced and not enhanced as a result. And even if DMA and Section 19A do away with the economic effects of in the market caused by and the enforcement of a competition authority, how do you or perceive those effects unfolding in practice?
We just fundamentally disagree with that potential outcome that comes from the FCO's theory. The one aspect we do appreciate in the FCO's decision in the public statements is that they have provided that we do not have to implement the prohibition order prior to any resolution on an interim measures proceeding, which we will be pursuing. At least we've got some ability not to have to do this before some of these legal questions are resolved by the Federal Court of Justice. That is helpful, and we do appreciate that. But the fundamental disconnect that on the consumer welfare side of it, whether you frame it as the standard or not, the fact that the outcome would be that the trust that we have built in our store over decades for our customers, that has benefited not just us, but benefited all the sellers that have grown massively across the store, small and medium enterprises across Germany. That is just harmful for everybody. It's difficult to see what the potential upside is to others in a long-term view. It's difficult to survey everything, but I believe it's just globally unprecedented to have a competition authority require a retail company to affirmatively promote uncompetitive prices to consumers. And whether competition authorities have different policy goals or other things, still, we have not seen anyone do this before. We're in uncharted water on that front.
You perceive those negative effects to crystallize as ripple effects on sellers, or what do you anticipate those effects aside from harming the consumer experience? How do you see the ecosystem suffering as a consequence?
If the featured offer can no longer be trusted by customers to be an offer that they can trust purchasing, that will be a good offer. That's not excessively priced and that's competitively priced. That means that they will no longer purchase in the store. From a perspective of the sellers, that's going to potentially hurt all of them too. And a lot will be left to the details of how this prohibition order is enforced and the scope of it, how broad it is, what aspects of the store it might apply to. We'll get to that when we get to that stage later on. And that's what concerns us about the theory and that aspect of the case. The decision really doesn't work through those issues. It seems to be focused on the complaints coming from some set of sellers, but not really thinking about the big picture. Of course, some sellers would like to have the ability to get the featured offer, even if they're priced at twice what normal prices should be, but that's not good for the broader set of sellers longer term.
Consumers not trusting the featured offer, customers then steer away from using Amazon, then the German and also the Europeans get contestability by enforcement, not really by the competitive dynamics unfolding in the market. And to wrap up the episode in terms of remedies, this is quite an astonishing case because this is the first time in history that the German Competition Authority opts to order the disgorgement of the economic benefits gained by Amazon through its anti-competitive behavior. You argue that the FCO's prevention of your price gouging mechanisms will lead to significant harm to consumers. How do you really expect the German Competition Authority to try to reconcile this contradiction, where it accounts on one side for economic benefits as an additional benchmark to set a fine, whilst on the other side, the net impact of its enforcement may result in a type 1 error?
This disgorgement of economic advantage is rarely used under German law. I think there might be one other case that it's been used in. And so that in itself is unique. It is a presumptive statutory amount. It's meant to get to this based on some notion that there has been some economic advantage. And then there's a statutory calculation, and you will see this once the public version of the decision is released, obviously. But once you get to a conclusion that you want to impose this, you just do a statutory amount, which is somewhat driven by percentage of revenue. Like much of the rest of the case, it's not really based on an assessment of impact or whether any economic advantage actually resulted from the conduct. And as you suggested in the question, if you have a disconnect between any unfair economic advantages that inured to Amazon because it is actually benefiting customers as well as sellers, it's not us jacking up prices and then somehow taking extra profit. It is all about ensuring that customers have good competitive prices. It's difficult to understand the approach and how it really applies, but because it is statutory, you don't have a factual basis on which to assess. Obviously, we'll be challenging that aspect of it too, as not grounded on the merits as well. But it is a unique one, rare, and we will see how it all plays out over time.
I'm really looking forward to whether you reach, as Amazon, the higher court in Germany, and maybe you can get through the Court of Justice and have a preliminary ruling dealing with these questions, not only on the merits of the case, but actually on how do we interpret Section 19A and the DMA. I have my own opinions on that, especially on this interplay, because I think that the passing of Section 19A is really contrary to the principle of primacy of EU law, and it should not apply at all. But that's my view, not the Court of Justice's. And I only wanted to thank you, Chris, for all of the discussion, and wanted also to highlight a few buzzwords that really struck me in the conversation. So we are talking about not assessing impacts in competition policy, addressing thin lines in enforcement, and also taking into account consumer welfare negative impacts. So I think that the audience can really get a gist of what the German Competition Authority's case impacts is going to be. Thank you so much, Chris, for joining the Agora.
Thanks so much, Ellie. We really appreciate and welcome the dialogue and discussion among academia and among others on these issues. It's worth the discussion and debate. So we appreciate you giving us the opportunity to talk about it.
Okay, thank you. Bye-bye.
Goodbye.